You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Thank you very much for joining us once again on another exciting episode of the Max Planck Lawcast. My guest on today's episode is Alice Margaria. Alice is an assistant professor at the University of Zurich and a research partner of the Max Planck Institute for Social Anthropology in Halle. She is also the author of the book, The Construction of Fatherhood, which was published in 2019 by Cambridge University Press. In this book, Alice looks at how the law, in particular the jurisprudence of the European Court of Human Rights, is dealing with what she labels contemporary fatherhoods. Today, we'll not just talk about the changing face of fatherhood in the 21st century, but also discuss the legal and practical consequences of bringing fathers' rights and responsibilities to the fore. Alice, welcome to the program.
Thank you.
It's good to have you here with us today. So, let's begin then. You introduced the term contemporary fatherhoods, but I just mentioned it there briefly in my little introductory spiel. As a father myself, I'm kind of interested to know exactly what you mean by the term contemporary fatherhoods.
Yes, when I talk about contemporary fatherhoods in plural, I refer to the fact that in present societies, there are many ways of becoming a father, of being a father, and of doing fatherhood. This is the consequence of a variety of societal, scientific, and demographic shifts, which have affected families more generally. So, for instance, the availability of assisted reproductive technologies, less marriages, high divorce and separation rates, unprecedented flows of migrations, or women's increased participation in the labor market. All these factors have had an impact on the way families are formed and family relationships are experienced. As a result of these changes, next to the conventional father, who is at the same time genetically linked to the children, married or in a relationship with the child's mother and the family breadwinner, there are many other ways, many other types of families and of fathers. So, for instance, there are gay men who become fathers through adoption or surrogacy. There are stay-at-home fathers who choose to work part-time or leave their job to take care of their children. There are single fathers. There are transnational fathers who migrate and work abroad but remain emotionally involved in the life of their children in spite of physical distance. There are also seahorse fathers, namely transgender men who give birth to their own children. This plurality and diversity of realities raises some basic but very difficult to address questions for the law. So the basic question is, what makes someone a legal father? On what grounds should a father be granted parental rights? Genetics, marriage, the intention of becoming a father, and in case there is more than one person claiming fatherhood, what grounds should prevail? For instance, does genetics trump intention or vice versa? Or is someone expected to be involved in childcare to be recognized as the child's legal father? Can a child have more than one father?
Okay, there's definitely a very fertile ground there for the discussion, I see. Well, could I ask then, because you mentioned the face of fatherhood is changing. One of those ones that when I was preparing for this podcast that I read up on was about seahorse fathers, and you mentioned them there briefly. I read a review actually. I tried to watch it, but I couldn't find it. But I did read a review of a 2020 documentary film called Seahorse, which is about a trans man and his struggle to conceive and deliver his own baby. At the very start of the review, which was published in the Guardian newspaper, it was noted, and I quote, "Across the breadth of fiction, the notion of male pregnancy has historically been played for laughs, terror, or most often a combination of the two. As you stated before, the reality is that trans men can now indeed father babies." Going a little further on from my last question then, what does this tell us about fatherhood in the 21st century?
Well, let me start by saying that I recommend everyone to watch Seahorse, and it's definitely a very powerful testimony of the pluralization of fatherhood, at least in Western societies. And more specifically, it draws our attention to the fact that following the gradual abolition of sterilization requirements for transgender people seeking to change the legal gender, there are now increasing possibilities for transgender people to become genetic parents. And Freddie McConnell, who is the protagonist of Seahorse, is one of them, is someone who chose pregnancy and childbirth as his path to become a father. When it comes to the recognition of fatherhood and of parenthood more generally, however, the situation is less rosy. With very few exceptions, and one of which is Sweden, trans men who give birth to their children are registered as mothers on the birth certificate of their children. And in Germany, they're even registered under their dead name, namely the name that they were assigned at birth.
So it was their dead name?
Yes, exactly.
Okay. Mm-hmm. Okay.
That name, yeah. So the reason for this is the rule mater semper certa est, namely the mother is always certain, according to which the birth giver is automatically assigned the status of legal mother. And in cases involving seahorse fathers, the rigid application of this rule is very problematic, as you can imagine, because it creates an inconsistency between the gender identity of the birth giver, who is legally man, and his parental status. And it also creates a problematic discrepancy between the parent-child relationship as registered, as recognized by the law, and the lived reality of those involved.
Mm-hmm. I think that's a very good point that you brought up there, and I'm going to return to that later on with a question about what the reality means with the law on one hand, but also traveling, for instance, around Europe or elsewhere on the other hand, what the actual implications are in such cases. Before I do that, though, I did want to talk to you briefly about your book, The Construction of Fatherhood. Looking over it, it has a European focus, I think it's fair to say. Are we seeing similar shifts on fatherhood and the way it's being defined elsewhere in the world as well?
I think so. So if we think about the US, for instance, Nancy Dowd, a legal scholar, produced very insightful scholarship on the regulation of fatherhood back in the 90s and 2000s. In a very well-known article entitled From Genes, Marriage and Money to Nurture, she observed that the US legal system had moved from a legal definition of fatherhood linked to marriage towards a legal definition of fatherhood linked to genes, thanks also to the possibilities offered by DNA testing, obviously. The so-called genetization of fatherhood is something that has been traced also in Europe, for instance, by Richard Collier and Sally Sheldon in their groundbreaking socio-legal study of fatherhood in England and Wales, which was published in 2008. So this emphasis on genes is also linked to another common development that is a broader gender-neutral shift in family laws, according to which mothers and fathers should be given equal rights with respect to their children. And I want to emphasize equal in a formal understanding of the term. And this is often translated into more rights, but not necessarily more responsibilities for fathers.
Okay. I'm going to come back to gender neutrality in a little bit as well. I wanted to ask, though, beforehand, I mean, you've obviously covered, you're an expert in this topic and you've covered it for numerous years now. Based on your academic experience, would you say that fatherhood, and let's say in all its various manifestations, is a well-researched topic in legal scholarship?
Not at all, actually. I think that fatherhood remains a largely underexplored topic in legal scholarships. The focus has been mostly and understandably on motherhood and on the broader regulation of parenthood. However, if we look beyond legal scholarship, we see that fatherhood has been quite extensively studied in fields like psychology, history, sociology, and anthropology. Social and cultural anthropologists, for instance, have documented varieties of ways in which fathers contribute to raising their children in different times and cultural settings around the world. In recent years, fatherhood has also attracted anthropological attention in the context of scholarship, drawing from feminist theory and looking at fatherhood through the analytical category of gender. So to give you an example, in the book Globalized Fatherhood, Marcia Hinhorn, Chapkin, and Navarro coined the term emergent fatherhood. And they coined this term to really capture the creativity and the hybridity characterizing the experiences of fathers in the 21st century, not only in the West, but in many global locations. So they basically tell us through this book that emergent fatherhood entails new forms of fatherly caretaking, often within the structure of busy working schedules, strict corporate cultures, and persistent traditional gender norms.
Okay. Well, I'm glad we're talking about the topic today. If you say that there hasn't actually been that much legal scholarship on it thus far. So good that we're adding to it. Good that you're adding to the research pool there. I wanted to ask about anthropology. I'm more of an expert in archaeology from watching Indiana Jones movies, so I don't know much about anthropology, I must admit, and how you actually integrate it into your research and what do you feel that the added value is that it provides?
Well, I integrate anthropology in my research on legal fatherhood at two different levels, at the conceptual level and at the methodological level. So from a conceptual point of view, my ongoing research understands legal fatherhood as a plural configuration in which a multiplicity of norms, experiences, practices, and narratives overlap and interact in time and space. Drawing from the kite model of law developed by Werner Minsky, I argue that if the aim is to harmonize law and society, and more specifically, in my field, if the aim is to create legal frameworks which address the needs of contemporary fatherhoods, then state law and international law shouldn't be the only or the primary sources of normativity. Rather, I think that equal weight should be given also to the norms by which people live. So this broad and pluralistic understanding of law has, of course, also important methodological repercussions. So it entails, first of all, to speak to the people, to give voice to those directly concerned. And this is exactly what I'm doing, in particular with seahorse fathers, really asking them about their experiences with the law and the impact that being misgendered as parents has on their daily life.
Okay, and maybe just as a practical example, how do you find people or seahorse fathers, for instance, to talk to? Do you advertise that you're doing research, or do they come to you? Do you go to them, or how do you do that?
A bit of both. So, for instance, some months ago, I was approached by a seahorse father and his legal representatives. They were looking for comparative European materials on the issue of birth registrations for trans parents in order to strengthen their arguments before domestic courts. But most of the time, it's actually me reaching out to them, especially when I sense that they're open to talk about their experiences. And the same goes with, for instance, another seahorse father that I had the chance to talk to. Actually, he decided to publish, to make available pictures of his, I think, the third birth. It was a home birth, to really kind of normalize, and I'm quoting him, to normalize trans procreation and to normalize trans parenthood as a reality of the 21st century. So some of them have the strength to also share the struggles that they go through in their personal life, not only legal struggles, but also really practical struggles, instances of discrimination, of stigmatization. In spite of this, they really have the strength also to make their stories known by the public and to sensitize public about trans-related issues and family diversity more generally.
Okay, well, very impressive. And as you say, also from them, the strength that must take to talk about that. Well, don't go away, because I'll be back shortly with Alicia in a moment to continue our discussion on contemporary fatherhoods.
Max Planck Law is a network of Max Planck Institutes engaging in legal research. The first of these was established in Berlin in 1924. Today, we cover a broad range of legal studies, from the anthropology of law to tax law. We operate one of the world's largest programs for doctoral and postdoctoral research in law. Visit our website today at law.mpg.de.
Well, welcome back to today's episode with Alicia Margaria on contemporary fatherhoods. Now, Alicia, before our little break there, you were talking about seahorse fathers, different, and anthropology and the like, and how this all works into your discussion. That being said, obviously, there's another side to the coin here, and there are a number of political and societal movements who would argue that the law, in particular family law, is biased against the rights of fathers, regardless of contemporary or not. Would you say that the law has traditionally prioritized motherhood over fatherhood?
Well, I think this is something that definitely deserves unpacking. So fathers' rights groups have been particularly active in the context, for instance, of separation and divorce. And one of their arguments has really been that family laws and judges are biased towards fathers and give more rights to mothers according to like gender stereotypical views about ability to care and parenting more generally. I have to say that these groups have actually been quite successful in pushing for the gender neutral shift in family laws that I mentioned before. And nowadays, in heterosexual settings, fathers and mothers tend to have equal rights after separation and divorce, often regardless of what happened before, often regardless of the childcare investments that parents, mostly mothers, made before a separation or divorce. And even more worrisome, sometimes also regardless of allegations and experiences of domestic violence suffered by mothers and children. So in this sense, I would certainly not talk about a legal prioritization of motherhood.
Okay, so you would say that is now, after the lobbying of groups, it's on a fairly even footing.
I would actually say that from this point of view, we see a legal prioritization of fatherhood, actually. That's what I would say if we think about the post-separation and divorce context. At the same time, I think it's also important to say that motherhood and fatherhood tend to be regulated as distinct categories. And sometimes I think that this is not ideal if the aim is gender equality. So let's think, for instance, of work-life balance, in particular maternity leave and paternity leave. So according to EU law, women have the right to a minimum of 14 weeks of maternity leave, and at least 2 of them are compulsory. If we look at paternity leave, well, first of all, paternity leave was introduced at the EU level only recently by the 2019 Work-Life Balance Directive. And according to this directive, fathers have the right, and I emphasize the right, not the obligation, to take at least 10 working days of paternity leave around childbirth.
Okay. And you said so before that women have the obligation to take 2 weeks?
Exactly.
Yeah. Okay. Whereas fathers have the right but are not obliged to.
Exactly.
Okay.
So, of course, I mean, as you can imagine, the introduction of compulsory maternity leave in Europe was a big success for women's rights, not only because of the health-related needs of the person who gives birth, but also to diminish the pressure upon working mothers from the workplace. So this was definitely a great success from women's rights and women's equality point of view. At the same time, I think that it would also be important to think about and to consider introducing a compulsory period of paternity leave for fathers. Not only because I think that also fathers might be placed under undue pressure by their employers, but also because I think that doing so would send an important message to society. The message that childcare, and in particular newborn care, is a responsibility as well as an ability of fathers as well. So I would say often women are in a weaker position and deserve greater attention also from scholars. At the same time, we also have to remember that if the end goal is gender equality, fathers have to be included in the care picture. They need to be given a realistic chance to be active fathers through, for instance, compulsory paternity leave or well-paid parental leave.
Okay. Well, who's going to solve this problem? I know you're particularly interested in the jurisprudence of the European Court of Human Rights. Are they redefining the way we see fatherhood and such the laws that are applicable?
Well, the European Court of Human Rights has been, and I think not always consciously, contributing to define who is a father over the last decades. And what my book shows is that the image of the father, which emerges from the case law of the European Court of Human Rights, includes both change and continuity. So on the one hand, we see that the court gives increasing importance to care, to the participation of the father in the child's life. And in doing that, the court departs from gendered and stereotypical notions around parenting and childcare. At the same time, we have to also say that the importance given to paternal care is not unconditional. In other words, paternal care tends to be taken into consideration by the court when conventional grounds of fatherhood, for instance, genetics, marriage, heterosexuality, are present. Basically, this means that while it is undeniable that the European Court of Human Rights has given protection to a variety of contemporary fathers, those fathers who cannot resemble the norm have been left out in the cold. And this
when you say the norm is a classical father, mother, or father, yeah.
Yeah, when I talk about the norm, I refer to another concept that I use in my book that is conventional fatherhood. So
Okay.
conventional fatherhood is this traditional ideology according to which the father is at the same time the genetic father of the child, so has contributed sperm to the child. So not any genetic link. It's a genetic link that has been established through sperm.
Okay.
Is married to the child's mother, or if not married, in a pseudo-marital relationship, so in a stable, long-term relationship with the
A
child's
de
mother.
facto relationship then
Exactly.
with the child.
And from this, we get the traditional mediated character of fatherhood, in the sense that fatherhood is very often traditionally understood not as a direct relationship between the father and the child, but rather as a derivative of the relationship between the father and the child's mother. And other two elements make what I call conventional fatherhood. And one is heteronormativity and cisnormativity. So the idea that a father is someone who was assigned male gender at birth and is someone who is heterosexual. And finally, breadwinning. So according to which the father's role is to financially provide for the family. So all these conventional grounds are all like possessed by one single person who is the conventional father. So when I talk about the norm, this is the norm that I have in mind, that of conventional fatherhood. And as you can imagine, there are certain contemporary fathers who, due to their personal and social circumstances, are not in a position of mimicking the norm. And so these are exactly the fathers who have been really left out in the cold, who have been left without legal protection by the European Court of Human Rights. And when I talk about them, I mean especially same-sex couples and transgender parents.
Okay, right. Well, then, if the European Court of Human Rights is leaving them out of their jurisprudence, by accident or not, what if I was to play devil's advocate here, which I do from time to time on the show, and argue that the solution might be that, okay, we want to achieve equality. Why don't we simply do away with these legal terms of mother and father and simply use parent instead? Where would you stand on this?
Well, your suggestion...
Have I solved the problems that the European Court of Human Rights hasn't?
I have to say that you're certainly not the only one to advocate for this solution. And actually, many scholars have argued for what is called degendering legal parenthood, that is essentially replacing existing categories of motherhood and fatherhood with the, I would say, apparently gender-neutral category of parenthood. And this is actually also a legislative reality in Ontario, Canada, for instance, following a reform in 2016. And I think that it's not difficult to see the many benefits that this approach would bring. So, for instance, in cases involving trans parents, this would solve the issue of whether parental status should reflect legal gender or birth-assigned gender. It would also have the advantage of accommodating non-binary parents, for instance. And more generally, I think that degendering legal parenthood would contribute to reduce the legal and the cultural power of heteronormativity. So for sure, there are many advantages in thinking about degendering legal parenthood. At the same
time, feeling you're about to tell me about the disadvantages.
Well, not really the disadvantages. I would say more like some conditions that need to be there for degendering legal parenthood to really bring benefits. And I think that degendering legal parenthood should be accompanied by legal efforts towards degendering care. So what do I mean by degendering care? I mean, we need greater legal efforts towards making care an ability and a responsibility for people of all genders. And in my opinion, degendering legal parenthood without a concomitant degendering of care might otherwise either play out as a mere semantic move with no change on the ground, or in the worst scenario, it might actually risk neutering care. And as a consequence, and here I'm quoting Marta Feynman, neutering mothering. So in other words, in the absence of efforts towards degendering care, degendering legal parenthood risks pushing towards formal equality without a prior challenging of existing gender imbalances in the family and in society. And this would have the ultimate consequence of ignoring and devaluing women's roles as primary carers.
Okay. So we're basically not at the societal point yet where we could go for a gender neutral term simply because the neutrality isn't there.
Yes, in a way. I mean, I'm not saying that we're not ready yet. I just think that degendering legal parenthood would work and would be more than a nominal move if there was like a broader, a structural, care-centered rethinking of fatherhood, essentially.
Okay. Wow. Yes. That's then a question, though, which is not purely of a legal, but also clearly a political nature. So it brings me to asking, how involved should courts be in deciding such matters?
Well, courts have a central place in deciding upon these matters, and eventually they're also those who really have to provide an answer to the many questions posed by contemporary fathers, with no possibility of delaying their decision. That being said, I think that also parliaments need to become more involved and create legal frameworks that are inclusive and socially sustainable. And courts are often those who kickstart processes of legislative reform by documenting decision by decision what are the needs, what are the realities, what are the experiences of contemporary families and fathers more specifically. And one of the many examples of this is the recent Swedish parentage law reform, which entered into force in 2019 and introduced birth registration of transgender parents in line with their gender identity. So Sweden is one of the very few countries, together with Iceland and Denmark, who adopted similar legal frameworks shortly after, where seahorse fathers are also fathers in the eyes of the law. And this reform was actually preceded by successful strategic litigation supported by trans activism.
Okay. I have a question then, though. You say in Sweden, Iceland, and Denmark, and this is my last question for you, but it's a very much a practical one. I guess I wanted to kind of get to the European approach then to fatherhood, and for that matter, motherhood. It's obviously a broad consensus is definitely necessary if we think about the free movement across the bloc and equal rights across the bloc. Obviously, it's going to be really problematic if fatherhood is recognized in one country, but not in another. What does the picture look like at the moment?
Yeah, what you say is a very important thing to think about. It's a very important concern in Europe and beyond, because of many reasons, families are moving across countries, are also moving across continents. But if we talk about Europe, and in particular, if we talk about the European Union, substantive family law is not an area that falls within the competence of the European Union, but it's an area that remains within the competence of the member states. So what does it mean? It means that, in principle, each member state determines the rule regarding the establishment of parenthood within their territory, and of course also the legal consequences that come from the establishment of parenthood. So exactly because member states have different substantive family law rules regarding parenthood, problems arise in situations with a cross-border element. So for instance, when a family moved from a country where their parent-child relationships was recognized to a country with a different legislation that doesn't recognize their parent-child relationship. So this creates what is called a limping status, right? It's like a relationship that is recognized in a country but not in another.
Limping as in when you walk, you have a limp.
Exactly.
Okay.
And the question of cross-border recognition of parenthood has been on the agenda of EU institutions for over a decade now. There have been a few decisions by the Court of Justice of the EU dealing with these matters. And in December 2022, the European Commission has actually adopted a proposal directed to solve these kind of issues. And this proposal intends to include also what is called a European Certificate of Parenthood, really to address issues of cross-border recognition. So hopefully this issue would be at least partially tackled by this new initiative at the EU level.
Right. Okay. Well, you've just given me a good reason to invite you back on the show in maybe a year or two's time to tell us exactly how things have worked out there, because that definitely sounds like a really important initiative, particularly, as you say, in an ever increasing international, cross-cultural, cross-border world. Alicia, thank you so much for joining us today on the Lawcast. I found it a really interesting topic. I learned a lot, and I wish you all the very best for the rest of your research there.
Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.